Okay, that's the recording and the transcript started. Don't forget, you can get these on my YouTube channel. I think I've also put last year's version on the YouTube channel, in part because of the issue we had a couple of weeks ago with the ethics assessment. So I've put last week's with the ethics lecture. So I've put last year's up as well. And there is slightly less in there of me going, why is Teams breaking down? Why is my computer not working? And a lot more about ethics. So feel free to use that one if you prefer. And this will go up once we're finished and it's been transcoded. Okay, so we're on to the third main section. We have done professional institutions, we have done ethics, and we're now moving on to legislation. And I want to start today by talking about that and what we actually mean by that. Because you can see there, the name that I've put onto this presentation is laws, statutes, regulations, and their scope. So what is the difference between a law, a statute, and a regulation? Can we ignore the statutes and follow the regulations? Is it only laws that we need to care about? And where do these things apply? What is the scope of the regulations that we work with? Which set of legislation do we have to live with? Is there more than one? Is it just the one that we're in? And that's important, because there may be 1, 2, 3, 4, 5 different legislative frameworks that we have to work under. So, for example, we're in Scotland, so the Scottish law. There is also English law, which is separate to Scottish law. But some pieces of legislation that are passed by Westminster are adopted into Scottish law. So they start in England, but get adopted into Scottish law. So in essence, they become British laws because they're the same law. However, it's still different legislative frameworks because Scotland has its own legislative framework. But there's 2 to begin with. That's 3. So there's Scottish law, drive over the border, English law, and ones that apply because they've been adopted into both for British law. You'll also see as we go through this, I'm still talking about some European laws, some of which still apply. And the most obvious one is GDPR. The GDPR laws in Scotland are the same as the ones in England, are the same as the ones in Europe, because they haven't been changed. So in essence, there's still some European laws apply, but not all of them. And that's very fluid at the moment, and I'll say that right at the start. So if I say anything and somebody looks up and goes, well, that's changed, I believe it. Please tell me, but I believe it because things are very fluid just now, because all of this Brexit stuff was done without actually figuring out what would happen afterwards. So we've got Scottish law, English law, British law, European law, and there's also another one, which is for many of you when you sign up for something, whether that's to buy software, whether to buy a service, whether it's just signing up for Twitter or Facebook or TikTok or Instagram, you'll have signed an agreement. And by a quick virtual show of hands, how many of you read any of those agreements when you signed them? So use a virtual show of hands or a wave or something like that. So two of you. Two of you read the agreements. So you've signed up to all this stuff, and this is a legal agreement, and you haven't read them. And one of the things that it'll say in there is, if you disagree with what you've signed up to, of course you can sue us, but you have to sue us where we are. So, for example, if you want to sue Facebook, you'd have to travel to California. Good luck traveling to California, getting an American lawyer, suing Facebook in California, where they employ thousands of people. So we'll get 5 different legislative frameworks that we might have to live under when, for example, you install a new firewall for your company. Scottish law, English law, British law, European law, and the law of some random software company that you've just signed up to. So it starts to get tricky. Stephen reminds me that someone pointed out, I mean, you see these things all over the place. There's a famous South Park one, but there was one company who right up front said, to use this, you sign over your body, and when you die, we can harvest your organs and they belong to us. And everybody just went tick. And as he points out at the end, they cancelled that clause, but nobody cared, nobody noticed, nobody read it. So these things are important because you are operating under a legislative framework for pretty much everything you do, and you may or may not know that legislative framework. But part of what you're going to have to do as a professional is understand that and be able to use that for your employer. Your IT people, who do you think they're going to come to when they want to know about GDPR? They're going to appear at your desk and go, tell me what we need to do to comply with this stuff. So you better know. And that becomes much more difficult when you have so many legislative frameworks that you need to comply with. Particularly if they belong in another country. And anybody who's ever watched any QI, for example, will know that a recurring trope on QI is stupid American laws. You know, don't go to Washington State and harass Bigfoot because that's against the law. If you happen to be in Kansas, don't catch a fish with your bare hands because you'll be arrested. And if you're in Georgia, you're allowed to eat fried chicken, but you're not allowed to use any cutlery. Good luck complying with all of those laws everywhere. Thomas, do you want to come in or you just accidentally come off mute?
Już idę.
Okay, Thomas, I'm going to mute you because I think that's an accident and you're doing something else. Okay, so let's get some terminology out of the way. A law is our rules, the ones that we live by, the sort of thing that Hollywood passes. A statute is slightly different because that's more of a way back when it was a royal command, now it's a command from Parliament or from the executive. And you'll see lots of things in the news, if you watch the news, about things like Henry VIII provisions taken on by Westminster. It basically allows them to create what are in effect laws, but without going to the trouble of actually having people vote for them. So they're quite a tricky thing. A regulation is like a sub-law. The idea is that you can modify a law without having to go back and redo the whole law. And the best example is the Health and Safety at Work Act. So there are lots of regulations that refer to the Health and Safety at Work Act, because the Act itself, and we'll talk about it later, the Act itself is fine in what it does. But when it first came out, which was several decades ago, nobody was doing what I'm doing, which is sitting here staring at a computer at my desk for 12 hours a day. So there was no idea in the Health and Safety at Work Act that you might want to take care of people who work with computers for a living. There was plenty on there if you wanted to take care of people who put up scaffolding for a living or worked with dangerous chemicals. But sitting at a desk working with a computer, no. So to address those kinds of things, regulations are brought in. And the one for us is the display screen regulations. And notice it's not even called a computer because it came out in the 80s and it was more likely to be a display screen onto a mini or a mainframe computer than it was to be your own PC. But it's regulations that have the full weight of the law, in this case the Health and Safety at Work Act, but can be added into the law without having to go through the whole thing of recreating the law and adding a bit in at the end. Gavin reckons there's a regulation about shooting a Scotsman on Jersey being legal, but only on a Sunday, and I think that's absolutely fair enough. But somebody can check that. No, Harry thinks it's in York rather than Jersey. Okay, so we've got laws, statutes, regulations, and we've also got the scope. And as I said, there are lots of different scopes for different legislative frameworks, depending where we are. But of course, the way things work, these are fluid. So I have changed some of the lectures to reflect some of the things that have definitely happened. I haven't changed some of the lectures to address some of the things that may happen. And the way things are, I may have left a lecture and the thing changes by next week, only to be reversed again the week after. So this is to the best of my knowledge at the moment, and I apologise if with the fluidity of the situation, I get any of the detail wrong. The good thing is anything that I say in the lecture, that's how it will be assessed. So even if I'm getting it wrong, you won't get the assessment wrong. So we've got different scope for legislation, which suggests that there's different institutions that enable those. We've got the Scottish Parliament for Scotland. That's the enabling institution now, but the Scottish Parliament was only reconvened in 1999. But Scottish law has always been separate from English law. So it used to be that the Westminster Parliament would be where Scottish laws were created too. Yes, this does get very confusing. So we've got Holyrood, we've got Westminster, and much less now we have the European Parliament. There's also different branches of the law. So criminal law. Criminal law is the one where when you watch things on TV, they're talking nonsense, because you'll always see things like, oh, well, they've done this, but I don't want to prosecute. Oh, the person's beaten up my mother, but I don't want to prosecute. No, you don't get the choice. The idea about criminal law is it's against society as a whole. Look back in all those ethics things and tell me what that comes under. So criminal law is things we don't want people doing no matter what. And it doesn't matter if you want them prosecuted or not. If there is the evidence, then the state will decide whether to prosecute, or in certain, as I say on the slide, very, very backward countries, it's not known as the state, it's known as the crown, because they still think there's a place for royalty in the 21st century. Criminal law is therefore a matter for all of us and can have penalties. Fine, prison, community service, whatever it happens to be. But there's also civil law, the one that's between individuals or individuals and organisations. You sue someone because you found a fingernail in a cake, that kind of thing. There may be a criminal part to that, because they've clearly not done what they should have done in terms of keeping their food clean, and that's a whole pile of legislation. But there might also be a personal part, that you didn't want to eat somebody's fingernail, so you sue them, and there might then be monetary compensation. In America, there was a case quite recently where lots and lots of people got together and sued Google because on the iPhone about 10 years ago, there was a setting that said, don't record where I'm going. And Google said, yep, yeah, we won't. And then it found out that they did. So there was a case in America where there was money taken for that. That also came, and it only finished last week, the week before, in the UK. It went all the way to the Supreme Court, and the Supreme Court in the UK turned it down. So there are differences in the approach to the legislation. The Supreme Court, by the way, turned it down not so much because Google didn't do anything wrong, but because they tried to sue on behalf of everybody who had been affected. So in other words, there wasn't a named person. Kieran's pointing out about Paisley being famous, and it is famous in terms of law, and it was it a drink or was it food? Trying to remember. It was a drink, yeah. So someone went to a cafe in Paisley, ordered a drink, and in the drink, in the bottle, was a slug or a snail or something. Cafe said, none to do with us, Gov. And they were sued, and they said, yeah, it really was something to do with you. Yeah, thanks. Kieran's put it in the chat. Donahue versus Stevenson. So yeah, there was something called precedent set there. In other words, someone sued, the judgment went a particular way, so that then sets a precedent for what happens in the future. And of course, there are different courts that you can go to. Basically, different layers. depending on how serious the case is. You know, if you're found drunk in charge of a bicycle in Scotland, you'll probably go to the Justice of the Peace Court and get a fine. Something more serious, you've broken in somewhere, you'll go to a sheriff court. I think the one closest to me is in Kilmarnock. I'm sure, almost certain there's a Paisley Sheriff Court. Something more serious, like a murder case, that will go to the Supreme Court in Edinburgh. Even more serious, it will go to the High Court for criminal stuff, or Court of Session for civil matters. And one I've left off there is that there's actually a UK Supreme Court that also will take appeals now as well. Gavin asks whether the snail in a bottle is a worldwide precedent or just UK, and the answer is neither. So we're talking about scope for legislation. It happened in Paisley, so it's not a worldwide precedent, although people in other courts may look at it, and that precedent has been used in other places to inform their decision. Similarly with the UK, because there's no such thing as UK law. But again, it was informed, and there was a similar thing in English law. It set a precedent for Scottish law. As I said, there is a Supreme Court for the United Kingdom. If the court case that you're involved in, you disagree with the outcome, you can appeal. And the appeal tends to go to the court one up, if you like. The European Court of Justice still exists, and actually you can still go to it for some things, but not others. So let's not go down the European Court of Justice or the European Court of Human Rights, because it's a mess right now. So you have to think about the jurisdiction. Sometimes it's simple. A Paisley woman sues a Paisley cafe owner in Paisley. That's Scotland. Easy, no problem. What happens though if there's multiple legislation? Multiple legislative frameworks covering multiple countries? What happens if I buy a new computer from a company in England? There's something wrong with it. Is that disposed of under Scottish law or under English law? Or where I get something imported from China, Scottish law or Chinese law? Just about every contract that you sign will make it clear. It will say, if there's a problem, here's how we're going to sort it out. In this particular one, it's in Houston, Texas, United States. And by signing up to that contract, by buying the thing, you have said, yes, I am okay with that. So you need to read these things. You need to read them personally, but you particularly need to read them when you're acting on behalf of someone else as an employee. Any other questions? James is wondering if you're happy with Pepsi flavoured escargot. I assume it's escargot flavoured Pepsi, or in this particular case, ginger beer. And escargot is great, although you don't taste the snail, it's just the garlic. Any other questions? Can't go wrong with garlic butter. Okay. If there's no questions, so that's the kind of broad framework of legislation. So what I want to do is look at some specific acts. And I've said before, this is a very small subset. They are ones that I think you will find useful. They're ones that I think you will come across, and they're certainly ones that I've come across in my career. Don't forget, I didn't always used to be a lecturer. I used to have a proper job as well. So the sorts of things that I would come across. So when we're covering these things, don't think that this is it. It's not. It's just everything that I can fit into this short course and ones that I have found useful in my career. There will be more and things change. So for example, you'll see a whole section on the Data Protection Act, which I haven't taken out. I've left in there just for interest. But the Data Protection Act doesn't exist anymore because it was taken over by GDPR. But I've left the stuff there because it's interesting to see how the Data Protection Act worked, the sorts of things that have continued in GDPR and the sorts of things that have been changed. In other words, it helps inform why GDPR ended up the way it was. So things change. So I'm doing some stuff. It's not complete, but they are, I think, helpful. That said, it's nearly 2 o'clock. I think we should take a comfort break. So shall we take 10 minutes? And I'll see you back in 10. Okay, and we're back. Music time, drink a cup of tea because I didn't. So I'm going to be grumpy for the last 3/4 of an hour. We'd left it actually talking about legislative frameworks under scope, and there was a question put into the chat because I'd been talking about GDPR, and Kieran had quite rightly pointed out the Data Protection Act 2018. So after me saying there was no Data Protection Act anymore, there is a Data Protection Act, and he's quite right. So let's examine why we have the Data Protection Act. We have GDPR. GDPR is an agreed approach to how data protection should work. And by agreed, I mean by all of the then members of the European Union. Because just like with any other agreement between those members, it made life easier for everybody in that block. However, despite what many politicians, most right-wing newspapers, and lots of excitable people on the TV were screaming about, there isn't really such a thing as European law in that sense. There was never any intent to have Europe legislating for member states. So when you listen to Jacob Rees-Mogg talking about how they're taking back sovereignty, sovereignty never left. So even though GDPR was agreed throughout the whole of Europe, in order for it to be implemented, each member state had to actually incorporate it into their own legislative frameworks. So the Data Protection Act 2018 incorporated GDPR into English legislation. It wasn't imposed, it wasn't forced, it couldn't have been done without agreement. So as I say, whenever you hear that on the TV, just mentally mark down whoever's talking about that as a fool or a liar. It was agreed, and then it was incorporated into legislation. English legislation, because it was done at Westminster. To incorporate it into Scottish legislation, we used what's called the Sewell Convention. The Sewell Convention says, okay, we agree with the stuff that's going through Westminster, and we're going to incorporate it into Scottish law. So that's how it got into Scottish law. But there is a definite difference between that process and getting GDPR passed at Westminster, because there was no mechanism for the European Parliament to force Westminster to implement that law. There might have been comebacks, there might have been, well, why did you agree if you're not going to do it? But that's a whole other issue, that's a political issue. There was no legislative way to do that. And up until about a year ago, there was also no way for that to happen between England and Scotland. Any acts passed at Westminster that were to apply in other legislative frameworks, specifically Scotland and Northern Ireland, had to be agreed by the devolved Parliament. That was then overturned. So now Westminster can legislate for Scotland, Wales and Northern Ireland, even if it's expressly against the wishes of what the people in those countries voted for. So this is where politics butts up against legislation. It's also where it starts being really confusing. So I hope that helps, Kieran. If not, I'm sure you'll put stuff into the chat. So when I'm talking about GDPR, Kieran's quite right. I'm talking about Data Protection Act 2018. I'm talking about GDPR because that's what everybody talks about, and of course it is still a cross-European procedure for doing all this stuff, and all the better for it. But we're not going to talk about that just now. We're instead going to talk about the regulation of Investigatory Powers Act 2000, or the RIPA Act. At least I would if I could keep up on the screen. There we go. For some of the things I'm going to talk about, I'm not going to go into all the detail about how it got into whose legislative frameworks, all the rest of it. I just want to be aware of that. And now we're going to talk about specific ones, and it will apply to a greater or lesser extent in most of the places that you'll work in the UK. If there's specific things, I might touch on them, but that'll be the last I'll labour on that. RIPA is the act that allows public bodies to spy on you. Some people might complain that spy is a pejorative word, but it's absolutely appropriate. It's surveillance, it's intercepting communications, it's looking at what you do online. Spy is a perfectly adequate catch-all word for all of those things. It was originally introduced by a bunch of politicians who didn't know that much about IT. Actually, that's unfair. They didn't know anything at all about IT. There was originally legislation that allowed things like you could go to court and ask a judge to allow you to tap a telephone. There's lots of safeguards. You had to go to court for what? For one, it had to be for a certain amount of time. Only certain people could listen to it. All that kind of stuff. There was a lot of worry back at the end of the 20th century that people were just ignoring phones and using email. I mean, wow, who'd have thunk it? So RIPA was brought in to allow access to all sorts of electronic communications. But as is often the way of right-wing authoritarian governments, we used the opportunity not just to plug a gap in the legislation, because what they could have done is just extend the previous laws and just say, well, what you can do on a phone, you can now do electronically, but you still have all these safeguards. Instead, they brought in a whole new piece of legislation because it allowed them to do a whole bunch of other things too. It allows public bodies to demand ISP access to communications. So a public body can ask for access to your emails or chats or whatever. And not just yours, you can monitor everyone's. Every single piece of data going through the internet all goes via the government and they can examine it. And ISPs don't get a choice in the matter because they have to fit the equipment to facilitate that. Everyone will have their own line about where they think things are, and I'm actually okay with the next one. Probably you know about public key encryption, and you can encrypt data quite easily. And it used to be that if you said to law enforcement, sorry pal, I've forgotten my key, there wasn't an awful lot that law enforcement could do about it. Now if you say that, police will go, oh, that's a shame. In that case, we'll do you under RIPA for not handing over your key to all this stuff that you've encrypted. So that becomes an offence as well. So there are lots and lots of ways to examine internet traffic, to examine your communications, and quite scarily, not allowing that to be known. So even if you're prosecuted using this, it can be hidden and not brought forward in court that that's happened. And you might think, well, yeah, that is quite tough, that's quite hard, but you know, it's a tough, hard world out there, and we want to be able to go after terrorists and child pornographers, and I wouldn't disagree. But you notice on that slide I've used the term a public body. This doesn't confine itself to law enforcement bodies. There's a whole pile of public bodies included in the legislation. The Charity Commission can spy on you. So can your local council. The Food Standards Agency can ask your ISP to see your emails. And of course, I mean, you can probably hear that I'm not too keen on some of these things, but if we can't all agree that the Welsh Ambulance Services NHS Trust should have the right to spy on your internet communications, then, you know, what can we agree on? On the module materials, you'll see a whole pile of these things. The sorts of people, the sorts of organisations that can use RIPA. So not surprisingly, that's taken a lot of criticism. It was rushed through really quickly without being scrutinised, because again, that's what right-wing authoritarian governments do. They prefer not to be scrutinised. They prefer stuff to be put through so that they can get what they want done. But in this case, what they got done is threats to civil liberties, the ability to spy on everyone, including children. There's even a long-running convention that if journalists come across wrongdoing, then you don't have to say who alerted them to it. RIPA gets rid of that. A journalist can be sent to prison for not revealing their sources. It has continued to be, the word that they use is strengthen. There have been more powers added. Now, I don't want to suggest that it's all bad. RIPA was used when the news of the world were intercepting the phone messages of dead children. Corrupt police officers have been prosecuted for unlawful surveillance. And people who have stored child pornography but took the precaution to encrypt it have been jailed. So even though we can't prove that they had the pornography, all the other surrounding information wasn't enough to prove it, but by not giving the keys, they were allowed to be put away. Now that's an issue if there's not enough surrounding evidence, but there have been some successes as well. And I'll leave it up to you to decide where on that line you lie between proper security and infringement on civil liberties. Any questions about that one? No. Okay. In that case, we'll move on to our next piece of legislation. And we've already spoken about it a little when we talked about regulations. This is the Health and Safety at Work Act from 1974. And as I said earlier, this is the enabling act, the overall one that places duties on everyone to be safe at work. As I said, it was deliberately written to be that sort of enabling act so that when things came along, they could be added in. So workplace regulations, manual handling regulations, display screen equipment regulations, all of that kind of stuff can be added in when there are things that need to be addressed. Now, again, if you read some of the right-wing press, none of this needs to be addressed. The Health and Safety at Work Act is the butt of so many lazy jokes that it would be impossible to cover them all. But it's a hugely important piece of legislation and has saved more lives probably than any other piece of legislation that I could think of. It's the sort of legislation that stops us sending kids up chimneys. Now, I've got a couple of kids and I'm not entirely sure I'm completely against it, but even if I was wanting to do it, the Health and Safety at Work Act would stop me doing that. Part of the reason that it gets such a bad reputation is things, fortunately, tend not to go wrong that often. 40 years ago, you couldn't walk down the street without seeing somebody who had lost a limb, or at the very least a few fingers, because of accidents at work. You don't really see that anymore. And that's in large part because we take that sort of stuff seriously now. But because it's taken seriously, people now seem to think that it's something that we can ignore. People aren't getting injured, therefore we don't need a Health and Safety at Work Act, which of course is remarkably faulty reasoning. And I know that I don't have to explain why that's faulty reasoning. It's always happened, and there's the quote. When anyone asks me how I can best describe my experiences of nearly 40 years at sea, I merely say uneventful. Of course, there have been winter gales and storms and fog and the like, but in all my experience, I have never been in an accident of any sort worth speaking about. I've seen but one vessel in distress in all my years at sea. I never saw a wreck, and I've never been wrecked, nor was I ever in any predicament that threatened to end in disaster of any sort. I cannot imagine any condition which would cause a ship to founder. I can't conceive of any vital disaster happening to this vessel, because modern shipbuilding has gone beyond that. Those of you reading ahead will know that that's a quote from the captain of the Titanic. People always think it won't happen to them. The Health and Safety at Work Act tries to make sure that it doesn't. The other attack is usually along the lines of, oh, nanny state interfering in everything. It's usually an attack, it has to be said, in papers owned by billionaires who have lots of vested interests in not caring about whether their workers are properly protected or not. But even as an attack, it doesn't really stand up to any sort of scrutiny, because one of the things that you'll see throughout the Health and Safety at Work Act is a phrase. The phrase, so far as is reasonably practicable. And that's an incredibly important phrase. It's dangerous to go up a ladder to wash windows, full stop. Some of the more excitable journalists suggest that the Health and Safety at Work Act stops you washing windows. Of course it doesn't. No one's saying that you don't wash a window. No one's saying that you don't walk up a ladder to wash a window. All the Health and Safety at Work Act says is, be careful. If the ladder isn't supported, get somebody to support it. So if somebody goes up a ladder and that ladder is in good condition, and there's somebody at the bottom making sure it doesn't fall back, and somebody falls off the ladder, the chances are there has been no effect under the Health and Safety, there has been no offence under the Health and Safety at Work Act, because you've taken all practicable steps. On the other hand, if you give somebody an old wooden ladder with broken treads and they're asked to go up and wash a window while the ladder's sitting on ice, well, yes, you will be done under the Health and Safety at Work Act, and quite rightly too. So the phrase, so far as it's reasonably practicable, doesn't stop you doing things. It just says, do your best to mitigate risk, because of course there's risk. I'm at risk here, sitting in front of this computer. My back hurts. My fingers hurt from using the mouse. My shoulders hurt from moving around. Don't stop doing your job. You take precautions. I went out and bought myself a chair that adjusts. I went out and bought myself a trackball so I'm not moving the mouse as much. And I just want to point out for people like Stephen that it's not about old age, because I am, of course, incredibly young. So there. Health and Safety says, be careful. It doesn't say stop doing things. If it did, there would be no cars left on the road. There would be no factories running. No one would do anything. That's not the point. The point is, if you're doing something and there's a risk, try and mitigate it as much as possible. And just to be clear, that's not just your employer, that's you too. Because employees have responsibilities under Health and Safety at Work as well. So it's not just about saying, oh, it's my employer. No, it's you too. So I talked about precedent before, and the precedent here is, in every case, it is a risk that has to be weighed against the measures necessary to eliminate the risk. So you can go up a ladder to wash a window. No one is suggesting that you have to build full-scale scaffolding around a house. But it's a balancing act, because it goes on to say, the greater the risk, no doubt, the less will be the weight to be given to the factor of cost. So if you can die doing something, you're going to put an awful lot of mitigation in place no matter the cost. Okay, so it's as far as is reasonably practicable, not as far as is physically possible. That's got a few sections talking about what it's to do, who it protects. And as I say, it's about employees, employers, but it's also about people that visit. So you have a responsibility to people that visit your premises, for example. And it's also about some of the basic stuff. It might be wise to take some precautions if you're storing explosives. Well, duh. And I say that, but some people didn't, because it would never happen to them. Section 2 talks about employers and what they have to do for their employees. And again, so far as is reasonably practicable. And it's just saying, be safe. Look at what you're doing, figure out what could happen, and be careful. And it could be something as simple as you're an IT tech installing a new printer. What could possibly go wrong? Well, anybody that's ever lifted a colour laser printer on their own will know that there's an issue there with manual handling. Anybody who's ever been unfortunate enough to spill some toner and sniffed it in will know there's an issue there. Anybody who's ever stuck their fingers in a printer to try and unjam it will know there's an issue there. So there's lots of things that can go wrong. But you have a duty to do that as well. If somebody comes along and said, how do you electrocute yourself? Oh, well, there's a bit of paper on the printer and I just stuck my hand in to see what could happen. You kind of have to take some responsibility there. Section 3 is about third parties, contractors, visitors, general public. So if you've got some scaffolding outside a shop, don't just put up the scaffolding, put up some netting so that if you drop stuff, it doesn't fall onto your granny walking past. Further sections go towards creation of things. Don't make a hammer whose head's going to fall off the first time you hit a nail. Test it. And quite often you'll see stickers to say that it's passed its safety tests. This is one of those places where we have an issue because the EU safety tests have now gone away. We do not yet have UK versions, so no one really knows what to do. As I said, it's not just about employers, it's about employees. And employees have a duty to take care of themselves, either by something they do or something they don't do. So you can't get over it that way either. And finally, there's a catch-all. And you can read the phrasing from the Act there. But I like to think it's, don't be an idiot. Any questions or comments on that one? Apart from mindless abuse telling me how old I am. Thanks, everyone. Every computer toolkit that I've ever possessed includes an anti-static strap, so that when you're working on systems, you don't fry the circuits. People forget it now, but again, that's part of stuff being made better, that things are fragile. Okay, we'll do one more, I think. We'll do the Freedom of Information Act. This is the one that allows you to ask public authorities, not private ones, so it doesn't apply to private organisations, but public organisations, and allows you to ask them for the information that they have on certain things. Again, there's one of these quirks where Westminster didn't do its homework, created the Act and went, this will do us, forgetting that Scotland has its own set of institutions and its own legislative framework, and in essence, it forgot a whole bunch of things that exist in Scotland. So after it came in 2000 at Westminster, there had to be another Act, the 2002 Act, to bring in all the public bodies that Westminster had forgotten about, or let's not beat about the bush, that Westminster hadn't bothered finding out about because they hadn't bothered doing their due diligence or consulting with people who actually knew about these things. This is about public information. So personal information used to be the Data Protection Act, and as Kieran pointed out earlier, still is the Data Protection Act, 2018 in this case, but it's what we most usually think of as GDPR. So this is about public information. Information that public bodies hold about what they're doing, for example. It's not everything. It's about public interest information. So, how many employees of your local council are paid over £100,000 is a reasonable freedom of information request, because that's public interest. It's a public body, the council is a public body, we pay for it, and you want to know whether or not the employees are being fairly or unfairly compensated. That's reasonable. A freedom of information request that said, how much does Sadie McClumfer in the accounts department get paid, is not reasonable, because it involves personal information and something that shouldn't be released. So there's a line between public information and personal information. And of course, where that line is sometimes tricky to understand, which is why there is someone called the Information Commissioner. Any freedom of information requests that, so if you make a freedom of information request to a public body, the public body turn it down, you can appeal to the Information Commissioner to say, I think this information should be released. And that then is the final arbiter. There's a Scottish Information Commissioner and there's an English Information Commissioner for the different legislative frameworks. The Information Commissioner can also rule on things that are called vexatious. Give me a list of all of your suppliers of toilet paper for the last 100 years. I mean, it might be something that you have. What are you going to do with that information? And people are not above making those kinds of information requests just because they can. Some things you just can't do at all. Stuff that you can get somewhere else. The number of freedom of information requests that are responded to by saying, go and look at the website, you doofus. I suspect they've got some kind of fancy legal language to say that, but that's really what it means. Security stuff, court records, the sorts of stuff that you would expect. Because I would absolutely expect members of parliament to protect themselves and say that they are not subject to this. And as I say, it's about public information, not personal stuff, and I've referenced the 1998 Data Protection Act, which should of course be the 2018 one. And I've also referenced EU stuff, because it's still fluid. So basically, any public body has to have a mechanism whereby you can request information. It used to be that there would be a physical form, or you would write to them, all that kind of stuff. That's not really the case now. Most freedom of information requests now are not surprisingly on a website. So there, for example, is the freedom of information request page for Glasgow City Council. You go online, you fill in a form and ask for the information that you want. Some public bodies don't like it. They don't want to be giving out that information. I tend to disagree with that. It was brought in by Tony Blair, who was the Prime Minister at the time. He says it's his biggest mistake. I can't say I agree. I think any organisation that spends public money should be accountable by whatever means. That's not to say it's not being badly used. You can barely open a newspaper or listen to Reporting Scotland without somebody presenting as news the results of a freedom of information request. So it does lead to things like lazy journalism. So it exists there, and it has, I think, been a success. Asking about fair dealing or fair use, that's more a copyright issue than a freedom of information issue. So we'll talk about that when we talk about copyright. Any other questions or comments? There's some links on the module information about some successes for FOI, including, some of you will remember, the expenses scandal at Westminster, where Westminster MPs were stealing our money. And there's some other things in there. So you can have a look at these. I'm not seeing any other questions or comments popping up. Which means that for once I have finished on time. So let me pause.
Just one thing I just remembered. Just an example of freedom of information getting my heckles up. Apparently, Glasgow City Council spent about $4,000 on meetings during the coronavirus, like from October 2020 to September 2021, which is a bit confusing because Zoom is £200 a year.
No.
So,
Zoom, a personal Zoom account is £200 a year. A commercial Zoom account is more like £150 a month, depending on how many people use it. And of course, it's not just about a Zoom meeting, it might be about other ancillary costs. So for example, I record this Teams meeting every time. You can also go onto council websites and see recordings of meetings. Quite often you can actually see them live as well. That also costs. So it costs for the software to broadcast it, it costs for the software to record it, it costs for the software to host it. So £4,000 for a year's worth of meetings, actually, that's really cheap. And I'll need to find out how they're managing that. Any other questions or comments? Okay, let me stop the recording.